I've got a green start now in front. So if you'd like to take your seats, we'll get underway. In the comfortable Holden Commodore seats, I've been informed that they're based on. Yes, easy to fall asleep, especially when I'm lecturing. Okay, so good afternoon, everyone, and welcome to the Shine Dome. Firstly, I'd like to acknowledge and pay respects to the traditional owners on the land on which we are this evening, the Ngunnawal and Ngambri people. It is upon their ancestral lands that the Australian Academy of Science is built. As we share our own knowledge, teaching, learning, and research practices, we also pay respect to the knowledge embedded forever within the Aboriginal custodian country. So, my name's Malcolm Sandbridge. I'm a Fellow of the Australian Academy of Science and Vice President. And I warmly welcome you here in person and all those online joining from home or where you ever may be across the country. I wish to convey the apologies of Professor Jagadish, the President of the Academy, who very much wanted to welcome you here but was unable, unfortunately, to be here this evening. We are delighted to be here in collaboration with the Australian Academy of Law. This is our 5th annual symposium together, and we greatly appreciate this ongoing relationship to deliver these powerful, thought-provoking events, and I think tonight will be no exception. This is the first in-person joint event in Canberra, and we're thrilled to be able to host it in the iconic Shine Dome, the home of science and the home of the Australian Academy of Science. Tonight's topic, drugs and addiction, can be taken in so many directions. And I think that was very clear when we had a Zoom earlier talking about it, and it went off in many different directions. And it was a case of bringing it together, and I think we've got a great program this evening. So we're very appreciative of the 4 speakers who join us from this and offer their own perspectives on this topic. Before we hear from them, a few things regarding tonight's event. If you'd like to join the conversation on Twitter, especially for those online, you can do so by using the hashtag SciLaw. That's SCILAW. And that will, if you're familiar with Twitter, it will do the Twitter thing. So questions from the online audience can be submitted by scanning the QR code on the screen. The QR code that will appear on the screen at home, and we'll pick those up and give the questions out to the audience. So questions from those in the Shine Dome can be asked at the microphone over there, at the Q&A session at the end. So now to get the event underway, we are honoured to be joined tonight by Justice Lucy McCallum. Lucy is the Chief Justice of the ACT and prior to her appointment was a Judge of the Supreme Court of New South Wales. Before this, she practiced as a barrister for over 16 years. She joins us tonight as our host and to facilitate what I'm sure will be an engaging and possibly at times controversial conversation. Thank you, and over to you, Lucy.
Thank you, Malcolm. I also would like to acknowledge the traditional custodians of the land on which we gather. As some people may know, there is a contest between different Indigenous mobs at the moment as to who those people are. And I can't think of a better way of resolving that contest than for lawyers and scientists to act as allies to all First Nations people having a claim to be recognised as traditional custodians. So if the anthropologists can talk to the lawyers and assist the First Nations people to resolve their disputes, that will make the recognition of country easier, less fraught, but certainly I wish to acknowledge that they are the traditional custodians and their sovereignty has never been ceded. Welcome this evening to this very interesting debate. As Malcolm said, it proves it promises to be, if nothing else, controversial. I attended the Zoom preparation meeting, appropriately or perhaps inappropriately armed with a gin and tonic, which I found that I was gulping hastily as I listened to the breadth of the different views that I was going to be called upon to muster as facilitator. But the point of the evening, I think, is to bring law and science together to see whether there isn't some common ground about some of the issues surrounding the way in which we treat the use and supply of drugs legally and the appropriateness of some of the laws in that respect. And our first speaker, the Honourable Justice Richard Refshauge, will give, I think, a very interesting introduction to that. His Honour graduated from the Australian National University with a BA in philosophy, honours in philosophy and an LLB. He was admitted to practice in the ACT in 1976. He practiced in commercial law, criminal law and litigation in a leading Canberra law firm. And I have to say, from my own personal experience, I often appeared against him when I was a baby prosecutor, and he was a criminal defence lawyer, quite often appearing for people charged with the possession or supply of prohibited drugs. And we used to refer to him as the man with the silver tongue, because he could always seem to persuade a judge or a jury that his client had only been handed the drugs by someone else who had then perhaps buried himself in the backyard somewhere and left his client was not guilty. But he has also served as the third Director of Public Prosecutions for the ACT, worked with the ACT government in a number of initiatives, especially in the areas of drug diversion, sentencing and family violence. His Honour was appointed a judge of the ACT Supreme Court in 2007, where he served for 10 years, and then 3 years after his retirement was again appointed as acting judge to supervise the drug and alcohol sentencing list. I'm not going to go through the whole of his curriculum vitae because his vita is long and therefore his curriculum vitae is equally long. But importantly, I think it's worth noting that he had 20 years as the chair of a drug rehabilitation facility, Drug Referral Information Centre, and a member of the ACT Supervised Injecting Room Advisory Council, and is presently chair of Directions Health Services. So I think he's obviously extremely well qualified to speak, and I understand that His Honour will speak about the history of prohibition of psychoactive drugs and will analyse the extent to which drug laws are evidence-based. Please welcome Justice Richard Refshauge.
Thanks very much, Chief Justice, for that very generous, overly generous welcome. While this is intended to give a picture of the history of drug legislation in the time available, it will really be just a snapshot. Much more could be said. What we now call illicit drugs, with other psychoactive substances, have been around for a long time, dating from at least the Egyptian Empire, where opium and hashish were used in at least the 3rd millennium, but mainly in medicine, for example, as a balm for the pain of childbirth, but perhaps not so much for recreational purposes. Nevertheless, there seems to have been little regulation of drugs, though some scholars consider that in the Sharia law there was some prohibitions, such as of hashish as a recreational drug. A number of Asian rulers also enacted such prohibition. Regulation through laws came much later in the West. The history of drug laws, however, is hardly a triumph of science and good policy. Though often misattributed to Otto von Bismarck, the thoughtful opinion of lawyer-poet John Godfrey Saxe in 1869 is very apposite. If you like laws and sausages, you should never watch either being made. More recently, this was echoed by the first Chief Judge of the ACT Supreme Court, Russell Fox, and a former editor of the Canberra Times, Ian Matthews, who commented that, quote, "The history of drug legislation in Australia has been clouded by ignorance, prejudice and false assumptions." During the 19th century, there was virtually no effective regulation of narcotic drugs in the United States of America, Britain, or in Australia, where the consumption of drugs, whether medical, quasi-medical or recreational, was largely a matter of personal choice. Opium was the most significant drug, as initially was regulated by colonial laws such as New South Wales and Victoria, their Poisons Acts of 1876, which provided that it was to be solely a doctor or a chemist from whom it could be purchased and labelled, quote, poison, unquote. The very first regulation was the imposition of customs duties on opium, and its theme of anti-Chinese discrimination was evident. Then, towards the end of the 19th century, more regulation was enacted. Opium simply was seen as a symbol of the Chinese and hated for that reason, where politicians and others used descriptions of it as a, quote, agent of vice, lethargy and filth, unquote, and a route by which, quote, innocent white girls were, unquote, were allegedly seduced by, quote, lustful and unscrupulous Chinamen, unquote. The first law prohibiting the smoking of opium was passed in South Australia in 1895, and other states followed suit by 1908. Interestingly, it did not prohibit opium contained in remedies of patent medicine, nor with its consumption as laudanum, not so much associated with the Chinese. It is interesting to compare attitudes then to more recently. For example, the Victorian Act, first proposed in 1893, provided that no person shall smoke opium, sell or deal or traffic in opium, or have in his possession, order or disposition opium in any form. The politicians of the day were mindful of the absolutism of such legislation. The bill lapsed, in part because it was felt that, quote, this was legislation run wild. It would be a draconian code. It would be a disgrace to the statute book of the colony, unquote. The Age, too, commented that the proposed legislation, quote, carried a stringency to the point of fanaticism, unquote. How times change. It's also interesting to see the prescience of some commentators as later in the early 20th century, successful bills passed some years later in the Commonwealth, despite considerable opposition from those who argued, as Mr Conroy did in the Commonwealth House of Representatives, that, quote, we're going to pass an act for the prohibition of the opium traffic in the full belief that the evil will at once disappear. I venture to say that the evil, so far from disappearing, will become 10 times worse than ever, unquote. Likewise, in New South Wales, William Holman, a future Premier, emphasised the, quote, unprecedented, quote, and experimental, unquote, nature of the legislation enacted in 1908. Quote, it's a most dangerous principle for the House to introduce in its legislation that the actual use of a drug of this kind by an adult should be made an offence, unquote. There was, however, soon international interest, led by the USA, which was on track for its era of prohibition in 1919, and which was crusading for wider prohibition. Thus, at the Shanghai Conference in 1909, called to discuss the British opium trade, the US was quick to claim the high moral ground and call for prohibition in an unqualified form, seeking to secure its reputation at the vanguard of international drug prohibition. The Hague Convention of 1912 then added to the prohibition of opium other drugs, including morphine, cocaine, cannabis and heroin. Much of this was political. For example, Britain was keen to discuss cocaine and heroin to draw attention from the profitable opium trade. Similarly, by then the Commonwealth had become interested, and soon the hesitation about absolutism was disappearing, so that in 1922 regulation prohibited not merely the sale of many of these drugs without a doctor's prescription, but also their mere possession. This was led by the international consensus, often from the US. Thus, strict prohibition, even severe penalties and punishment for possession seemed to have been almost unquestionable by then. Much of the development was linked to the association of activities, such as cocaine being linked with prostitutes in King's Cross, who were said to be addicted to it. So that drugs were considered, quote, evil, unquote, because evil people used them. The Commonwealth took a strong lead, but mostly through customs and not health. In 1953, it wished to ban heroin, despite originally no state supporting that, as it was widely used, especially in childbirth, indeed by my father, and was as a doctor, not as a producer of children, although I suppose in a way he did produce children. Sorry. And it was regarded as, quote, effectively controlled, unquote. Nevertheless, the international pressure weighed heavily on the Commonwealth, and the states finally caved in to pressure being the principal reason for the legislative ban. The Single Convention on Narcotics Drugs in 1961 brought together the various international agreements, but at the time there was little illicit use of drugs to test whether prohibition was actually effective. Then in the 1960s and 1970s, the influx of American soldiers on leave from the Vietnam War increased the use of drugs, as did the mood of the youth. As use grew, so did more prohibiting legislation, fueled by views that drug use was causing drug users to be, quote, rebellious, as they didn't live with their parents. They didn't do the washing up. They spent a lot of time with their friends, and they stayed up late, unquote. No one worked out that they were adolescents. One terrible suggestion was that the use of marijuana meant that the users were likely to be yielding to homosexual advances. Thus came increased penalties, the width of drugs prohibited, and means of proof, for example, by deeming possession of certain quantities to amount to trafficking. Finally, in 1989, the Commonwealth created the Drugs of Dependence Ordinance 1989 for the ACT as a model legislation for Australia, though by then most states had their own legislation which was similar. Since then, interestingly, a large number of efforts have been made to wind back this approach with diverse approaches such as diversion schemes, drug courts, and a greater recognition of the health as the appropriate lens through which to deal with the consequences of drug use. But unfortunately, this is beyond the time that I have allotted for me. Thank you.
Thank you very much, Justice Refshauge. It is very interesting to reflect on the political imperative for some of those laws, which, as you have rightly observed, are now welcomed, and some people call for them to be strengthened, and we'll hear more about that, I think, this evening. Our next speaker is Professor Carla Treloar, who is the Scientia Professor and Director of the Centre for Social Research in Health and the Social Policy Research Centre at the University of New South Wales, which happens also to have a mighty law school from which I graduated. Professor Treloar is a leading international expert in social research in health in marginalised groups with a focus on stigma and trust in health systems. She has more than 25 years of experience in public health, health services and translational research. Her work brings to light the gaps, failures and harms of health and social systems and poses solutions to better meet the needs of people who experience social marginalisation. And I understand that this evening Professor Treloar will speak from her experience as a social scientist on the social impact of stereotype and stigma on access to drug rehabilitation treatment. Would you please welcome Professor Treloar?
Thank you, everyone. I also acknowledge the traditional custodians of the land on which we're meeting and acknowledge that First Nations people have borne the brunt of harm of drug laws since colonisation and since more recent war on drugs legislations, and currently as well in terms of over-incarceration of First Nations people and people of colour. So thank you for inviting an outsider. I'm neither a fellow of the Academy of Law or the Academy of Science. I'm a social scientist. I'm a fellow of the Academy of Social Science. And my job as a social science is to analyse the ways in which laws, which prohibit some drugs, impact on the rights, the health and the lives of people who use those drugs. My colleagues and I, we look across the law and media and the way that organisations and services are set up and run, interactions between people and the psychological impacts of being criminalised and othered in our society. Of course, the law isn't everything. For example, South Australia was the first to repeal all acts of, decriminalise all homosexual acts in 1975. But I bet there hasn't been a day since without homophobia, stigma and discrimination of gay and lesbian people. So the law doesn't solve all of societal's ills, but obviously it provides some protections and it enables community agency to claim rights. So I'm going to focus on stigma. Stigma towards drug users, drug use, people with addiction, people seeking drug treatment is off the scale in every measure that we've taken. In 20 years of doing qualitative research and survey research, it beats just about everything that we've measured. It's pervasive and really high. It's one of the winners in the perverse race of stigma. So the impact of living with a stigmatised condition or practice means an individual is pushed to the margins of society. It's really hard to step up and identify with as living with a stigmatised condition or identity or practice. So for someone who's prohibited on top of that, the fear of repercussions are even greater. If I turn up at a service to seek help, will my children be taken away? Will I be subject to police attention and thrown into the criminal justice system? Will I have to meet and perform to unreasonable expectations just to get basic care? We have documented and measured each of those things. In our last survey of people who inject drugs, we asked, in the last 12 months, have you delayed or avoided healthcare because of the fear of stigma? And without missing it, 70% of our respondents, which is almost 1,000 people across the country, saying, yes, I have, in the last 12 months, not turned up to a health appointment because I'm fearful of the way I'll be treated. So obviously, every time we miss an opportunity to provide care, we make the next interaction more expensive. More expensive because the risk of someone's ill health becoming worse increases. It has impacts to the individual, it has impacts to our population, it has impacts to our health systems. And again, changing the law won't immediately fix that, but it will give us some additional tools to examine the ways in which services are set up and run. Are they fit for purpose for meeting the needs of people who need and seek care from them? So stigma, there's numbers of sources of stigma: the fear of peril, the fear of, the notion that people are to blame for getting themselves into the predicament that they find themselves. And these notions are often driven by misunderstandings or lack of understandings of, in this case, drug use, drug addiction, drug treatment. And it is such that those notions of drug use are very easily conflated with the notion of drug addiction, that we can't seem to hold as a society that these things are different. But sometimes that confusion, that lack of understanding is put to good use. And I'll draw attention to the work of Kate Sear from La Trobe University, and Kate's both a sociologist and a solicitor. So she's done research with court actors, interviews with lawyers about how do they work with this notion of drug use and drug addiction, excuse my lack of understanding, on the court floor. How do they do it? And sometimes this lack of understanding and stereotypes are put to use to benefit their client. Yes, Your Honour, my client, again, I don't know really what language I'm using here, but yes, Your Honour, I've only seen it on TV. My client was found in possession of drugs, but they've realised the error of their ways. They've turned their life around and they're taking concrete steps to becoming a worthy, legitimate citizen. Hogwash, right? But it is an argument that works because it's feeding off those stereotypes, the stigma and the lack of understanding. Doesn't mean it's a good thing to do, but it's a way in which lawyers have found to use those stereotypes for good and not evil. So we know the vast majority of people who use substances won't need any professional help. Many of you might go home and have a substance tonight and not at all see yourself in the realm of people needing professional help or treatment. But the current discussion around some drug law reform is that we should treat this as a health issue. We should refer everyone we find with drugs to a health service. Waste of time, waste of services. For people who really need drug treatment and want to get there, there's so few places there to ambush drug treatment services with this wave of people coming from these perhaps palatable, it's a health issue, we should get them health help. It's a total waste and unethical use of the scarce resources for people who really need help. Perhaps we should focus on harm reduction services for people who might want to check in on their use at various points. There's also a tendency that is bound with these notions of stigma and prejudice to simplify our categorisations of people. So again, around drug law reform, we hear some talk of trauma. So yes, undoubtedly, some people who experience drug dependence have histories of trauma. What's problematic about that is that if we use that to create simple binaries, over here are the people who've experienced trauma in their past and they've used alcohol or other drugs to help cope with that trauma. We understand, we're compassionate, and we see them as worthy of the services, the scarce resources and services we have as a society. Over here are the people who don't have a history of trauma. They've got themselves in their own predicament and, we don't see them as worthy. We see them to blame for just wanting to have too much of a good time. We don't ask health workers to make an assessment of how fast someone was going before they fix their bunged leg from a car accident. Yet people who use drugs feel they're often seen as not making enough of an effort when they turn up at health services. They have to perform in certain ways to get basic care. So getting close to wrapping up, this stigma we can also see at the political level and its interference with the ways in which services are delivered for people who use drugs or not delivered. So in New South Wales, we've seen drug services very susceptible to political whims. Some services closed in the lead up to state elections as candidates campaign on law and order bases, and somehow these very well evidenced services are caught in the crossfire of that and forced to close as a political response. In the ACT, the Prime Minister intervened to stop the planned heroin trial in the 90s, and that meant that for more than 2 decades, people who really need that service haven't been able to get it anywhere else in the country. No other place has been brave enough to stand up, though we might hear some change about that soon. We only have 2 safe consumption sites in Australia, one for people who use illicit drugs, one in Melbourne, one in Sydney. Though there's safe consumption sites for alcohol on just about every corner of every city and every town. But the Catholic Church intervened from the highest levels when this Sydney site was being set up to remove St Vincent's as the operator, because it was somehow deemed that the people who want to use that service weren't legitimate, weren't worthy of investment, weren't credible patients for the Catholic Church and its service arm to care for. So my message, I guess, is that life isn't reducible to stereotypes, but stigma and stereotypes infect all of our responses to drug use in modern Australia, and that's held for decades and centuries, actually. Patterns of drug use are complicated and messy and fun and not so fun. And with colleagues out of an ARC Discovery grant, we tried to collect all this and put it in that beautiful glory messiness as a public-facing education resource. So go and check out Lives of Substance as our website. It's beautiful, it's great, gives you all the types of ways in which drugs appear in people's lives for good and perhaps sometimes not so great times. Thank you.
Thank you, Professor Treloar, for what I'm afraid I have to say was that depressing segue back to reality, and perhaps we can explore some constructive ways in which we might address some of those vexed social issues. Our next speaker is Professor Arthur Christopoulos, who is the Professor of Analytical Pharmacology and the Dean of the Faculty of Pharmacy and Pharmaceutical Sciences at Monash University. Prior to his appointment as Dean, he was a Senior Principal Research Fellow of the National Health and Medical Research Council of Australia. His research focuses on something I'm going to try to read without faltering, is novel paradigms of drug action at G-protein couple receptors, the largest protein target class for modern medicines, which incorporates computational and mathematical modelling, structural and chemical biology, molecular and cellular pharmacology, medicinal chemistry, and preclinical models of behaviour and disease. This work has been applied to fundamental and translational studies encompassing a vast range of medical conditions listed in his curriculum vitae. Professor Christopoulos has also published over 350 publications, and there are too many of them to read in the time I have available to introduce him. It is enough, I think, to say that he is highly awarded, highly decorated, and highly enthusiastic about mind-altering substances. Professor Christopoulos is going to speak from the perspective of his pharmaceutical experience and pharmacological experience about what we're missing in the utility of some substances that are prohibited and the harmfulness of some substances that aren't prohibited and perhaps should be. Please welcome Professor Christopoulos.
Thank you so much. I also want to begin by acknowledging the traditional custodian to the land and reiterate the message that Carla made, that First Nations people are one of a number of groups that are overly marginalised and stigmatised by the subject matter that we are talking about today, and that's something that's very close to my heart. I've been a pharmacist for over 30 years now and a neuropsychopharmacology researcher for most of that time, and one of the things that struck me as I started out in practice and absolutely horrifies me now is the fact that virtually all existing medicines that are used to treat psychiatric diseases are based on science that is at least 50 years old, and most of it through accidental discoveries. Now, that is unacceptable. Now, there are a number of reasons for this, but I don't have time to go into all of them. But the reason I'm standing up here today, at least the 50-plus year war on drugs that has been so comprehensively lost has a lot to answer for in this regard. And it's through this lens that I would like to present three arguments or considerations of where the science is ahead of the law when it comes to how we view illicit, prohibited and or recreational drugs. The first one I call the neurobiological argument, and I'll keep that relatively brief. It's now clearly acknowledged that addiction is a disease, whether it's addiction to alcohol, to heroin, to a prescription medication, or even to sugar. which is the latter being a key driver of the current obesity epidemic, by the way, addiction is literally associated with changes to both brain chemistry and brain structure. And that's across a range of different structures, whether they're evolutionarily new or old. So to cut a long story short, prolonged exposure to psychoactive substances, legal or otherwise, can and does change both the signalling, the anatomy, and the function of the brain. This is no longer a hypothesis, this is a scientific fact. Which brings us to the second point, the pharmacological argument. Given that any exogenous substance that we introduce into our body has the potential to mimic, to block, or to modulate hardwired neurochemical or neurobiological processes, it's axiomatic that there will be consequences, both foreseen and unforeseen, when such substances are ingested. The entire basis of pharmacology as a discipline is to use our knowledge of chemistry and biology to perturb living systems for therapeutic benefit. However, in the pursuit of better, safer, and more effective medicines, especially in an area such as mental ill health, we need to be able to access and utilise substances that contemporary research is clearly telling us may work better than the current standard of care. And if you're looking at 50 years, you've got a long way to go. But some of these substances remain out of general utility because of current laws and regulations, and this is a significant impediment to progress. Now, we at Monash University recently established the Neuromedicines Discovery Centre, and one of the main areas of focus is the potential benefit of currently prohibited substances such as psilocybin, the active ingredient of magic mushrooms, and MDMA, the active ingredient in ecstasy, to revolutionise the way that we can treat psychiatric diseases such as depression, anxiety, OCD, feeding disorders, and substance use disorders, just to name a few. In fact, the extant science and clinical trials to date in support of these substances are already stronger than the science behind the potential benefits of medicinal cannabis, which is already out there. Yet there remains a disconnect in our ability to access and use these potential medicines in a timely manner that can make a huge difference, particularly to those most marginalised in our society. Moreover, a recent study by one of the world's leading neuropsychopharmacologists, Professor David Nutt, and his colleagues, called the Australian Drug Harms Rating Study, examined the psychological, medical, and social harms of various substances in population. This study found that the worst offenders by far were alcohol, ice, heroin, nicotine, and methadone in that order. In contrast, MDMA and classic psychedelics were literally at the other end of the harm spectrum. And in the middle, you've got prescription opioids, amphetamine, and cocaine, somewhere around there. So in terms of harm minimisation, we already have got it. I think we've already got it wrong, that it is almost unethical not to revisit this from the ground up. And that takes me to my final point, which I refer to as the regulatory argument. The TGA, the Therapeutic Goods Administration, of course, is responsible for what medicines get registered in Australia, just as the FDA does in the US. The main legislative instrument by which the TGA makes medicines available to the public is through schedules within the poison standard, of which there are 10. Now, I'm not going to go into them, but I will highlight 3 that are pertinent to today's discussion. First, Schedule 9 substances are prohibited substances. That's the bad stuff, right? An important and explicit criterion in the current system for Schedule 9 substances is that, and I'll quote, the substance has no currently established therapeutic value and is likely to present a high risk of dependency, abuse, misuse, or illicit use. So some key examples of Schedule 9 substances include heroin and speed, but also psilocybin and MDMA. Second, Schedule 8. They're the substances that are called controlled drugs. Examples of those are obviously things like fentanyl, codeine, methadone, oxycodone, as well as stimulants such as Ritalin and certain types of amphetamines used to treat ADHD or sleep disorders, okay? But you can get those, okay? That's Schedule 8. And of course, Schedule 4 substances are prescription-only medicines, and that title pretty much explains what they're all about. But some pertinent examples of those include benzodiazepines, such as Valium, antidepressants, such as Prozac and other SSRIs, antipsychotics, such as clozapine, and most antibiotics. For frame of reference, however, paracetamol and aspirin sit under different schedules, but nonetheless, they are readily available over the counter, as are alcohol and nicotine, albeit in a different context. But knowing what we know now, and if we had a clean slate, what would we do in terms of the intersection between the law and science when it comes to pharmacological substances that may or may not be historically classified as illicit? So, what I'd like to leave you with are 3 interesting facts that I hope draw together some points raised above about impediments to research on psychoactive substances, the concept of harm minimisation, the idea that what is a legal versus an illicit substance should not just be a case of legal definition, but contextual on the setting in which that substance is utilised, and the fact that the science is often ahead of the law in this area, such that we need to urgently address this imbalance. So, fact number 1, as I said, psilocybin and MDMA are currently Schedule 9 substances. That means same category as heroin and ice. And by definition, no currently established therapeutic value and likely to present a high risk of dependency, abuse, misuse, or illicit use. Now, this isn't correct for a few reasons. First, multiple clinical trials have already shown substantial efficacy of these substances in a range of psychiatric illnesses using a clinical paradigm where they are only administered a handful of times, under strict supervision, and after which the patients undergo non-medicinal psychotherapy. In fact, based on the most recent clinical trial data, MDMA will likely get FDA approval within the next couple of years for the treatment of post-traumatic stress disorder. Second, there are literally decades of research that have unambiguously shown that no one has ever become addicted to a psychedelic drug. If you actually understand the mechanism of action, you can see why you can't. Although it is possible to become addicted to MDMA, this would only occur through repeated, frequent use, which is not how it would be used under clinical supervision. Fact number 2, the therapeutic index of heroin is 6. That is, the difference in dose between getting an effect and the dose that kills you is 6-fold. The therapeutic index of paracetamol is 10. The therapeutic index of psilocybin is 1,000. Psilocybin is safer in overdose than Panadol. Fact number 3, if aspirin were discovered today, it would either not get TGA approval or it would be placed in a much more prohibitive schedule due to what we now know about its efficacy versus its side effect profile. The same can be said for certain antibiotics due to the significant number of patients that experience allergic reactions upon their administration. Okay? So I guess to conclude, the divide between science and the law when it comes to how we approach and regulate medicines and drugs, especially in the psychoactive drug space, is vast. There are numerous historical reasons for this, but in this day and age, I believe we can and we should do better. Thank you.
Thank you, Professor Christopoulos. And it's interesting you're talking about psilocybin because I've been listening recently to a podcaster, Sam Harris, who describes himself as a philosopher, neuroscientist and author. And he teaches a great deal about mindfulness and ways to find happiness. And from his meditation history and his what he calls his gap 10 years that he took before he went to university, or gap decade, keeps harking back to his own experience of psychedelics and the positive impact that they had on him. It's not, I hasten to add something that I've tested myself. Our next speaker is the final lawyer in terms of our 4 panel speakers, Nicholas Cowdery. Nicholas Cowdery, AOKC and Fellow of the Australian Academy of Law. And for those of you who haven't been following the news, the KC stands for King's Counsel. Was a barrister for 46 years, practising chiefly in criminal law. He was the Director of Public Prosecutions for New South Wales from 1994 to 2011. He is now an adjunct professor teaching at the University of Sydney and occasionally elsewhere. He was founding co-chair of the Human Rights Institute of the International Bar Association from 1995 to 2000 and president of the International Association of Prosecutors from 1999 to 2005. He has written and spoken on drug law reform for a very long time. He's the author of Getting Justice Wrong, Myths, Media and Crime, published by Allen and Unwin, and Frank and Fearless with Rachel Jane Chin, and Discretion in Criminal Justice. And I do have an outline of the speaking notes that Mr Cowdery is going to address, but it's probably easiest simply to repeat what he said at our preparation meeting, which is that he's going to throw the legalisation bomb.
Well, thank you, Chief Justice, for the very generous introduction. I echo the remarks of others and acknowledge the traditional custodians of the lands from which we are all meeting, both here and online, and acknowledge that the sovereignty in those lands has never been ceded. The first thing I should say is that the views I express are my own. Although I am a Fellow of the Academy of Law, I do not purport to speak for the Academy. So please understand that. I understand the prohibited drugs we are discussing tonight to be those drugs in association with which may attract a criminal penalty, and I'm proceeding according to that definition. We're not particularly talking about nicotine, alcohol, or even sugar that are drugs and can be addictive. Nor are we talking particularly about addiction, because most prohibited drug use does not lead to addiction or dependence and is not otherwise problematic. Listening to what we've heard, and without doing justice to it all, a story has emerged for me. The story is that over time, moral decisions have been made about drugs and about individual drugs for which there is no scientific or evidence-based foundation. Somebody, somewhere, at some time, has decided that a drug is not only bad, but so bad that it should be punished by law for a person to be associated with that drug. For me, two failures emerge from that. The first is that it might be thought that the imposition of a criminal penalty for individual conduct would be supported by sound reasons, but that has not occurred. The second is that there might be some consistency of approach to drugs, but that hasn't occurred either. If society chooses to prohibit conduct, there must be sound and consistent reasons for doing so, and not just arbitrary moral assessments based on paternalistic notions, racism, of which we've heard some already this evening, or worse motives. But the real conundrum for a lawyer is why anybody should think that the criminal law is the right mechanism for dealing with what is essentially a health and social issue in society. I can tell you, after 53 years' engagement in criminal justice, including prosecuting and defending drug cases, that criminal justice is particularly ill-equipped to deal productively with drug users, possessors, and non-profit suppliers who cause no direct harm to others. In New South Wales, there is a prescribed maximum penalty of 2 years' imprisonment for even attempting to possess or attempting to self-administer a prohibited drug. Where did that come from? And there are often unintended consequences. To take just one example, it's an offence to drive with any trace of cannabis in your body. And cannabis THC, being fat-soluble, can hang around in your system for days without impairing your driving in any way. That unfairly and inappropriately penalises those using prescribed cannabis with CBD and THC for medicinal purposes, some of whom then avoid the medicine in order to be able to drive. But the law doesn't budge. The speakers tonight have described many issues that arise. As we've heard, stigma may attach to drug users even if they're not caught and legally punished. In my limited time, I'm proposing a better way forward. So cover your ears, put on your helmet, this is the bomb. Steps have been taken towards decriminalisation of some drugs. Now that means that association with them remains prohibited and criminal, but no penalty or lesser penalties apply. Essentially, it's the wimp's way out. Better than nothing, but only just. Such also is President Biden's recent pardoning of federally punished cannabis possessors, as politically significant as that may be. There will always be a demand for drugs, so there will always be a supply. While the market remains illegal and involvement brings risks, there will be excessive profits to be made to be applied to other criminal activity. The only rational, principled and effective course to take, as I see it, in the real interests of society, is to legalise, regulate, control and tax all drugs, as we do now for nicotine and alcohol. And they're two potentially very harmful drugs, as we would all know. Nicotine kills 21,000 people in Australia each year. That's 58 people a day. And when I talk about this regime, I mean all drugs. Different regimes would be required for different drugs, but we do that already with nicotine and alcohol. To settle on the best model for each drug, well-targeted and comprehensive surveys could be conducted, as was done in Canada and Switzerland before cannabis legalisation in those countries. Maybe a national citizens' assembly could serve a useful purpose. The new regime would start with the growth and manufacture of the drug. That should be licensed, and in this and other steps, licenses would be hard to obtain and easy to lose. Product quality would be monitored. Points of sale would be established, also licensed, as occurs in those jurisdictions where recreational cannabis has been legalised. So far, in 7 countries, let me remind you: Canada, Switzerland, 19 of the United States of America and Washington, DC, Uruguay, Malta, Germany, and the Netherlands. Limits may be placed on availability. There could be educational material and support services promoted to customers, as the medically supervised injecting centres do now, but with modifications, of course. There would be age limits on purchases and control of advertising and packaging. The whole process would be taxed. And if you like, the tax may be hypothecated, earmarked, to be applied to relieving the effects of problematic drug use, which I acknowledge does occur. The bogeyman ICE would not be exempt. Legitimate access would be more likely to identify and intercept problematic users of this and other drugs than the present exploitatory system of distribution. Heroin could be made available on prescription, as it is in the United Kingdom to treat addiction. It would then be provided under continuing medical supervision, with all that entails. This approach would do away with an illegal market that creates harm additional to the harm already possible in drug consumption. Additional harms of disease, death, secondary crime and official corruption, criminal profits, not to mention the psychological and practical harms to consumers as a result of the intervention of the criminal law. The stigma of criminal prosecution, expense and inconvenience of participation in proceedings, effects on the ability to travel, study, obtain employment, and take part in voluntary work, far outweigh any benefits to society from imposing criminal sanctions. We have created the conditions for criminals to flourish and users to suffer by the laws that we have made. And then we spend vast amounts of public resources attempting to reverse those effects. Would it not be better to prevent most of this from happening in the first place? The criminal law would still be available to use against those seeking to operate outside the licensed systems. The aim should be to remove the criminal profits from the drug trade at the same time as reducing the harms that may be caused by the use of all drugs. We have failed at both so far. There are no signs that we can do better under the present regime. So, in my view, radical change is necessary. It is happening elsewhere, step by step, and eventually we will catch up. Thank you.
I would ask all the speakers actually to come back up to the stage now, take seats so that I can facilitate questions if people have any. And while they're coming up, I would like to thank Mr. Cowdery for that extraordinarily thoughtful analysis, which is quite thought-provoking. If there aren't questions from others about it, I've got one or two of my own. So the first question I have from the audience listening remotely is from Andrew Perusco, a PhD student at ANU. And he asks, I'll have to bring it up closer to the... Considering that the total social costs from illicit drugs, tobacco being 56% of the total, alcohol about 26% of the total, dwarf those of other drug use, and that tobacco control policy internationally is moving toward tobacco endgame approaches, what framings are important for rational drug policy reform in Australia? And I think that's probably, it's a question to the panel, but it might be appropriate for Mr. Cowdery to answer that question.
It may be that I've already answered in
Yes.
what I had to say, so perhaps it might be interesting to hear the views of some of the other panel members.
Well, any basis in rationality would be a good start for drug laws.
Agreed. I mean, the first thing I wrote down was, as Nick was talking, was evidence-based. And in fact, I can actually read you through. I wrote evidence basis and consistency, not the wimp's way out.
I agree.
And there is another question from Paul. Not quite sure where he's come from, but similarly asking how, commending Mr. Cowdery's idea, but asking how realistic is it and how would it be implemented. Could I add a follow-on question to that, again for Mr. Cowdery? I'm sorry to put you in the hot seat, but you said that ICE would not be exempt. In my experience, both as a barrister but more pertinently as a judge, ICE is the one drug I see truly causing decent people to do terrible things. And you say that it could be dealt with on the basis that legitimate access would be more likely to identify and intercept problematic users. But once problematic users are intercepted, then what? Do we prohibit their use of it? And if so, is that something that's sounding a bit like an aspect of criminal or punitive treatment of that particular drug? And perhaps separately, and this might be a question to Arthur, do you share my concern about ICE as the bogeyman, as Mr. Cowdery called it?
Well, it is the bogeyman, and it's discussed that way by many people in many circumstances. The reason why I would not make an exception comes partly from this. In the medically supervised injecting centre in King's Cross in Sydney, people bring a whole range of drugs to inject. One of the drugs they bring is ice. And talking to the medicos at the centre, they have not encountered any of the behavioural difficulties with people who have injected ice in the centre. The sorts of problems that you hear much more about from, for example, country towns, where motorcycle gangs come into town and peddle ice to people, initially sometimes by offering it free to young, unemployed, aimless people, and then getting them hooked, and then increasing the doses, and then the behavioural problems develop from that. So those are the sorts of things that I have in mind. No, you wouldn't, if somebody exhibited bad behaviour, violence, whatever it might be, under the influence of ice, you wouldn't then seek in some way to prohibit them individually from any access. But there would be other measures that must be able to be devised to address the problem that is then surfacing. I don't pretend to have all the answers to all the issues that would arise in relation to all the drugs. That's for a long way down the track, obviously, if it were ever to happen. But surely it's not beyond the wit of men and women to develop programs that would deal with that. At the same time, removing the criminal profit. That is really one of the major things that we have to do.
Yeah, so I guess my perspective is obviously a little bit different. I look at in terms of what is ice? Okay. Ice is a crystalline form of methamphetamine. Methamphetamine as a powder can be both used and abused, and in fact methamphetamine is used clinically for certain. In fact, MDMA is 3,4-methylene dioxymethamphetamine. So MDMA is a methamphetamine derivative that it's much safer than methamphetamine itself. Ice is a pure crystalline form of methamphetamine, which is extremely potent, and in terms of therapeutic utility, I would not see that it has valid therapeutic utility, given that we have other options to be able to achieve such an outcome. So I do see it as a boogeyman substance, and I do see it as a problem. However, it's a different issue to, I guess, what Nick was being asked is how do you deal with people once you're in that situation? But ice scares me in terms of what it can do.
And perhaps the answer is if you went down the legalisation path, that the crystal form of the drug wouldn't be on the menu. Richard. Sorry, do you mind going to the microphone? And while you do, I think Richard wanted to add an answer to that question.
I don't disagree with Nick's approach. Indeed, I very largely support it. But I do think there are some practical problems. And one of the things that I think we've got to deal with is that it's all very well to say access to these drugs will allow some kind of process to manage where things are getting out of control and not. And I think we need to give further thought about that. One of those problems is the availability. It's all very well in King's Cross to have an injecting room. We're never going to have an injecting room in Walgett. What do we do about people who want to use these drugs in Walgett? How are we going to manage that? Not in the sense of prohibition, but in the sense of protecting us. Having said that, of course, there are huge problems, and one of the bigger problems, in my view, in our courts, not so much the illicit drugs, but actually alcohol, which is hugely problematic. in driving areas, in domestic violence, and in so many other spaces. We don't have any of these kind of things. You can go into a pub. Yes, you can't be served while you're drunk, as long as the overworked bartender can recognise that you're drunk. But you can buy as much as you want, and you can take it home and you can drink it for all you're worth. So that, you know, perhaps the society has got to accept, and this may be one of the changes, has got to accept that there will be issues, there will be problems, and then balance whether those problems are going to be worse than the problems that are created by our current criminal justice system. And that opens up problems about the university of crime, i.e. the production of recidivists, i.e. prisons, and all those arguments. So it's really complex, and while Nick's solution is simple at one level, and it does pick up all those other issues about evidence and fairness and so on, I think it is complicated, and we need to work through those things and understand the balance that we're making about what we're doing. But one of the things that I think is important is that the balance, even with some of those problems that I identify, will almost certainly not be as bad as the situation we have now.
Professor Bartels. Excuse me. There we go. Sounds like it's on now.
Okay, thank you. This is a follow-on question on the ice issue. I talked to a number of people who've had ice addictions with ADHD and who've used ice to calm them down, and at times said, oh, well, I only use ice because I'm treated like a junkie and I can't actually get my lisdexamfetamine or Ritalin or Concerta or whatever. So that also goes to the issue around stigma. So not all ice users fit within the boogeyman stereotype either, and I think we need to unpack, and that's true of people who use a range of substances in the same way as not everyone who drinks alcohol is an alcoholic, but I think especially with ice we have this monolithic demonised user conception without recognising that pharmacologically ice has similarity with, as you've said, what we use to treat ADHD, and I know a number of people who say, I actually only use ice when I can't get access to what I need for my medical condition.
Yeah, I think that's an important point, and I'd certainly be the first to acknowledge that my experience is very jaded, and it comes from the exposure I have to seeing terrible offences committed by people at the extreme end. It would be a nice, I guess, kind of epilogue if I then became afflicted by PTSD from exposure to those cases and was prescribed MDMA. Then I might have a better understanding. But I'm very happy to accept that the court's experience is jaded in that way.
Since I do have the mic, and that was more of a comment, for those who haven't heard of some of this really exciting research on the psilocybin and ketamine and stuff like that, are you able to speak a little bit about that? Because I think that is something of a game changer, bearing in mind that not everyone who uses drugs has trauma, but some of that emerging evidence is, you know, especially stuff around veterans and the overrepresentation of veterans in the justice system. I think some of this stuff is really pretty remarkable.
I totally agree with you. I mean, most of the study, Nixon's war on drugs basically stopped research in this space for around 50 years. It's only around the turn of the millennium that researchers were able to start accessing, even though it's still very hard for us to get access to this, to do even clinical research. It's overly burdensome, but it's true that there's been so many small clinical trials to date that have suggested larger trials are now worth running. MDMA is by far the most advanced. This past year alone, the phase 3 clinical trial, the first phase 3 clinical trial with MDMA was published in Nature Medicine, run by the MAPS group, and that's why, and it's actually was shown to be better. In fact, 2/3 of the patients suffering from PTSD at the end of that study no longer were classified as suffering from PTSD. There are a number of now phase 2 trials with psilocybin, large ones undergoing, but even some of the smaller ones that were published even last year in the New England Journal of Medicine have shown that psilocybin, at least in patients with depression that were compared head to head with an SSRI, it wasn't better, but it wasn't worse either. And the treatment paradigm is completely different. The way these substances would be used in a therapeutic setting is you'd go once under clinical supervision, you would take it then, and then you would have a period of what they call integration, where you're not on any medicine, but at least for a week or so, you're doing non-medicinal psychotherapy. Then you essentially rinse and repeat, 3 times, about a month to 6 weeks apart. And then, and depending on the condition, the remission rates can be, quite startling. So it's a different paradigm. It's basically, you only use it for a brief period of time, and the idea is to get off on the medicine, to get off medicines. The problem that we're going to have is, even at the point of registration or regulation, these substances, you can't unlink them from the therapy that goes with it. It's called set and setting, mindset and setting, which is administered. So I think the regulatory hurdles that we're going to be facing is, how do you register this at the end of the day, because you're not going to register the drug alone. You're not going to go to a pharmacist with a script, get a psilocybin and take it home. So the challenge we'll be facing is, how do you're going to have to regulate both the drug and the associated therapy, but it'll happen. People, once people work out how to make these things work, and once they show they can make money out of it, don't worry, it happens.
Now, before I come to the gentleman with the lovely accent, I'm going to go to another question from the virtual audience, which is from Darcy from Kalgoorlie, and he asks, and I'm afraid, Mr. Cowdery, it's addressed to you again. He asks, wouldn't the enormous structures and scaffolding needed to support the many laws and taxes you suggest for drug decriminalisation weigh it down so much that sourcing drugs legally might cost us all, financially and otherwise, more than the current costs of prohibition?
I didn't pretend this was easy. And I certainly don't pretend to have all the answers. But I would answer that question by saying that I think, on balance, the benefits to society overall would outweigh the harms that are presently being done. And if we have to pay something to get to that position, then I think it's money well spent. Yes, there would be quite a structure to be put in place in respect of each drug. But the efforts could be coordinated. There would be a lot in common from one drug to another, and a lot of differences too. And a suitably qualified design body, I'm sure, would be capable of constructing and putting in place the kind of systems that would be needed. And if it costs some money, we are going to be saving money elsewhere, and we are going to be eliminating harms that we've been grappling with now since the politically motivated war on drugs was begun in the 1970s.
Carla, you wanted to add to that?
Yeah, so this is something that probably doesn't sort of chug along by itself. There are other initiatives, justice reinvestment for one, where knowing that there are concentrations of people in prison who come from defined areas. Sometimes in the US, blocks in a city have really enormous incarceration rates. So some of the work in that area has been to slice a bit off the top of the incarceration budget and put it into community development of highly incarcerated areas. And in some cases in the US, that's led to savings and drops in prison. Like, hard to imagine that the US has a drop in a prison population, but yes, in some places it's sufficient to mean that prisons have been closed because there isn't enough people to fill the beds. So drug decriminalisation or legislation alongside really nice social policy and community development is probably a way to understand the fuller costs and savings we could be making.
Can I just add, from some direct experience, to put this in a little bit of context? As Chief Justice mentioned at the beginning, I now supervise the Drug and Alcohol Sentencing List, which is the ACT's version of a drug court, and that was recently reviewed by Professor Bartels and her team, and what they found was, in the time since it started, which effectively was 2019, but really about 2020, to when the review was released earlier this year, the estimated savings to the ACT community was $14 million. They were still in the system, they were still being managed, they were still addressing some issues, but they weren't going to prison. And that was saving $14 million. So when we say there's a huge infrastructure that will be needed and, all this sort of stuff, there are also huge savings too, and we need to recognise that's the kind of scale of magnitude that we're talking about.
Thank you. Yes, sir.
Thank you all. It's been fascinating and fantastic to hear the perspective from the legal profession, which is something I don't hear very regularly. I would ask what your opinions might be in addressing, very gratifying to see your commitment to evidence. And evidence is frequently presented to a number of coronial inquiries or special inquiries. How does the scientific and legal professions, including medicine, combat the situation where evidence is simply ignored? So we've seen these inquiries be presented unanimously with evidence as to what should be done, say, in New South Wales and Victoria, and it's just ignored. The other part of that is, how do we combat influence? And by that I mean there are certainly entities, there is the establishment, the edifice of prohibitionism that makes money out of prohibitionism, even in Australia. There is big pharmacy, which is disinclined to find cheaper, more effective ways of providing therapeutics. There's the hospitality industry, who thrives off the retail of alcohol. How do we use the leverage of such august bodies to address such iniquities in both evidence and influence?
So these aren't, this isn't my clever phrase, but it comes from Alex Wodak, who refers to drug policy as an evidence-free zone, and that everything we put is, the arguments for law and order are just evidence proof. One thing that's disappointing to me is the disappointing and whatever the opposite of disappointing is, the numbers of global leaders who post-career have a revelation that current drug policy is pretty crap, and they find themselves and they position themselves on this august international body called the Global Commission on Drug Policy. So Helen Clark is on it, Kofi Annan is on it, our own Jeff Gallop, Premier of WA, is on it, and many others. From around the world, but it's always post-career. Wouldn't it be great if those people had the courage to stand up during their career in power and say, we need to do things? And things have happened. That's how the Medically Supervised Injecting Centre in Sydney came about at the beginning of this century. It has happened, but this notion that somehow drug policy are too far, it's too far, and presenting all the evidence. David, and I know you've banged your head about pill testing for forever, fighting the good fight. It's really frustrating, and we are here as no one declared yet that any of us use illicit drugs, and the people who do use illicit drugs and who are out as community advocates have been doing this work for decades, and that must just be so disappointing as they see their friends, lovers, colleagues experience the harms of our poor, inadequate, hurtful, harmful, racialised, gendered drug laws. So this is the thing, it's this part, it's talking to people who might be in positions soon or in the future who can take these hopeful gems of wisdom with you into whatever careers and spheres of influence you have, to write the discussion and put in some good evidence to convince your colleagues in the spheres of influence that you find yourselves in.
I think that's
whilst you're doing your work, not after.
I think that's an excellent point, Carla, and I'm not sure if it answers your question, but we did talk in the pre-planning meeting about seeing if we could get someone to come and present this evening who had experience with addiction, and I did actually try to follow up on that. There's a lovely chap called Jeff Amato, who had a long experience of addiction to drugs and sort of revolving door incarceration. He then got into the Glen, which is a drug rehabilitation centre on the Central Coast, which I've been to. It's a fantastic place. And that was sort of his, the thing that changed his life. And he spent the last 12 years, I think it's actually 13 years now, clean and sober, and basically touring the country, talking and raising money for his sort of little limited idea of less jails, more rehabilitation programs. I can't remember the catchphrase, but it's something along, less incarceration, more rehabilitation. I asked him, because I'm looking from a different perspective of ways in which, following off on Lorana's report of the drug and alcohol list, we can improve outcomes for Indigenous offenders, because one of the things the report identified was that just as Indigenous offenders are overrepresented in incarceration rates, sadly, they're overrepresented in failing in the drug and alcohol sentencing list. So we're looking at how we can improve outcomes for them. But in that context, I met with this chap, and he said every time he came out of jail, he was still addicted because drugs are readily available in jail. He's illiterate. He doesn't have any identification papers. He had no money to buy a transport ticket to get back home on country with his mob. He was homeless. And he just said he basically had absolutely no prospect of breaking that cycle until he was referred to the Glen, which fortunately now also has a female rehabilitation centre, which I like to call the Glenda. They haven't taken it on, but that I think that it doesn't really answer your question. But if we can, it perhaps addresses Carla's point that if we can have the courage to acknowledge the success stories, then hearts and minds might follow.
I think that's very true. It does seem to me, I mean, this probably is a question to be posed not so much at a lawyers and science symposium, but a political scientist symposium, where unfortunately in our political discourse, loud assertion replaces evidence. And I think what we need to do is get our stories out, because I'm convinced, and I perhaps got my head in the air, but I am a judge after all, that most people do actually understand if they're given the opportunity for someone to explain. And I think if we get our stories out, we will get the community generally to understand these things. And we need to talk to them, and we need to talk to them respectfully and politely, and not assume that we're the fount of all wisdom, but explain what the evidence is, what the results are. And some glimmer of that was given to me when I read in the Canberra Times, and I shouldn't advertise, but I do read the Canberra Times, one of the current unfortunate victims of a child car accident death was saying about what he wanted. He was posed in the media as being, we've got to cancel bail and up sentences forever. Well, he explained that that really wasn't what he was doing. He was interested in rehabilitation. He was interested in other ways to go.
He just wants safer roads.
He just wants safer roads. And there are lots of things that could be done apart from putting people in prison, which are likely to let them go out, having heard what the other experiences of those in prison are about how you do it without being caught anymore. And so I think there is a lot of that we have a responsibility to get our message out, to get our evidence out in a respectful way. And if we do that, I'm sure that the community will then recognise that some who just shout loudly are not actually shouting the truth, and they can understand.
Arthur, you want to add something? No.
Could I just, before Arthur comes in, if I could just follow on from what Richard has said and go back to David's question. Policy in this and so many other areas must be evidence-based to be effective and to be legitimate. Getting our political representatives to act on the evidence is an extraordinarily difficult task. And I'm sure David had in mind the so-called ICE inquiry in New South Wales, which produced 109 recommendations. Almost immediately, the government dismissed 6 of them and said, we're not doing that, and we'll think about the rest. 32 months later, they told us what they thought about the rest. Now, this was a fully funded government inquiry headed by a highly respected and competent professional, taking evidence from all around the state about this, compiling all of that, presenting the most detailed and reasoned report that you could possibly imagine would come from an inquiry of that kind. Ignored. On the shelf with all the other Royal Commission reports and the special inquiry reports and all the rest of it, because they're full of evidence. And we certainly don't want to be acting on that. So the answer to your question, I think, is that politicians need to know that the community wants change and will support change. And if they make the change, they won't be voted out at the next election. Now, how do you get that across? You can only do that through the electors, through the voters, through the public. One of my retirement hobbies is going around talking to things like Probus clubs and University of the Third Age and people who are even older than I am. And when I talk about, things like drug law reform, and back in years gone by, I was talking about abortion decriminalisation and voluntary assisted dying legalisation. When I talk about these issues and present facts to audiences of 80, 100, 120 old fogies, they almost universally come out in support of what I'm suggesting. Now, I don't claim to be a charismatic speaker. I'm just giving them the evidence. And when they see the evidence, they respond appropriately. And I think that's what we have to do. We have to keep taking it out. This symposium is an example of how we get these messages out to the people. Sorry, Arthur, all yours.
Arthur, very quickly, and we have one more question and then I'll have to call on.
No, I was just quickly going to reflect on my own recent experiences in the MDMA and psilocybin space. The question is, what does it take to cut through? And part one is me as an expert getting out there and saying to them, here's the evidence and I'm putting my reputation on the line. 2 is knowing, people with lived experience also cut through very, very quickly. And 3 is, we have to produce the change agents starting with ourselves. We can talk more about this later, but I know but that's what I'm finding. I've been working on this for 2 years, starting with Greg Hunt and all the way now to the Victorian State Government. I'm still going.
And there is one more question online, and it's a quick one, I think. It says, do you think the demand for dangerous drugs would reduce if all current illegal drugs were legalised? I think no one can know the answer to that, but except Carla.
Well, not just me, although, that would be great. Portugal decriminalised drugs in the beginning of this century, and lots of indicators of harm went down. The sky hasn't fallen in. It's been 20 years. They've just quietly done it. We've got that evidence.
That's interesting. I always thought as a style of parenting that if you could make something daggy, which legal things are, then that might discourage your kids from getting engaged in those activities. Kevin, would you like to come and wrap up for us? I was running to time in a military-style precision, but now I'm a few minutes behind. But we'd be grateful if you could wrap up for us. Thank you. I'm sure you all know Kevin Lindgren. Do I need to introduce you?
First, could I apologise for the absence tonight of the President of the Australian Academy of Law, who would be doing this if he were here, Alan Robertson, who is overseas. It's my pleasant duty in Alan's absence to thank the Chair, Chief Justice McCallum, and our 4 speakers. Now, I've sometimes attended seminars and symposiums where the person moving the vote of thanks has given brilliant summaries of what the speakers have said. I don't think mine will be so brilliant, but speaking briefly, Richard Refshauge kicked off the evening giving us the history of legal regulation of drugs. Professor Carla Treloar gave the social science perspective and talked about the psychological effects of drugs in society, in particular the effect of stereotyping, stigma, blaming and self-blaming. Professor Arthur Christopoulos spoke from the pharmacological perspective. I was interested that he spoke of the harm scale in which alcohol has the worst record. He also spoke about the inconsistent scheduling of various drugs. And I think he made the comment, one never becomes addicted to a psychedelic drug. The final speaker was Nicholas Cowdery, who gave us what he describes as the decriminalisation bomb. And he made the point that the history of legislation in relation to drugs is that they begin with moral decisions, one might add by the politically powerful at the time, and then legislation follows and conforms to those moral judgments. He said that we should legalise, control and tax all drugs. And you heard the debate in relation to ice. So we have had a really interesting night surveying the topic by eminent speakers. In expressing our thanks, I speak on behalf of the two academies and those who are present here in the audience tonight, and also those who are online. The topic is a really important one, and we are fortunate to have had fellows from the various academies so eminently qualified to speak to us. May I also, on behalf of the Australian Academy of Law, thank the Australian Academy of Science for its hospitality in hosting the event at the Shine Dome. I do not foresee a time when the Australian Academy of Law will have premises to compare with the Shine Dome, but we have been blessed with the Federal Court of Australia allowing us to hold events in the court. So would you now please join with me in expressing our thanks in the usual way.
Yes, I think it remains for me to say that we have refreshments in the Jaeger room, which is that way. West. I think I'm pointing west. I'm just going to follow the scientists.